Alrighty. Well, thank you everybody for joining us. You should have just gotten a notification on your screens that this webinar is being recorded. I will share more on that momentarily, but thank you for joining. I'm going to go ahead and throw up my quick introductory slide deck. All right. Well, thank you everybody for being here. We have, I'm going to save our introductions for Caitlin, who will introduce our speakers this afternoon. But I just wanted to thank everybody for joining us for this AICP exam prep session on law. And the CM number is indicated here, and I'll also put that in the chat box momentarily with the link to the actual AICP CM search page. The Your Hour with APA Virginia is generously sponsored by the Berkeley Group. Thank you to our partners there. I will note that we are, in an unusual on an unusual date for the Your Hour series. We typically hold them on the fourth Monday of every month. And so this is a special case, but we will be having another webinar at the end of the month on March 24th, and that will be with DHCD on economic development and community vitality programs. I just wanted to run through a couple of logistical and housekeeping items before I hand it over to Caitlin for introductions. So this is I will be linking in the chat our website page for our chapter, and then also for our conference page, which is apavirginia.com. Quick conference plug. We have been thrilled with so much interest in presenting at APA Virginia 2025 in Portsmouth in July, and we're happy to extend our both our call for session proposals and our award nominations through the end of the week. So it was had previously closed on Friday, but we are extending it another week. So March 7th at midnight is the new deadline, and we encourage you to take advantage of this opportunity if you'd like to be involved in the program. So some quick logistical items for the webinar. We really do encourage questions. Please submit your questions through the Q&A box as opposed to the chat box. This will just help us keep track of all inquiries. If there's ever a point in which there's an opportunity for an open-ended question or open-ended response, feel free to use the chat box. And then once we get to a formal Q&A at the end, feel free to use your raise hand feature to request to be unmuted if you prefer to ask your question out loud. But otherwise, if you have questions and you think of them throughout the webinar, feel free to throw those in the Q&A whenever you think of them. I think that about wraps it up. I did know earlier that this webinar is being recorded, and so I will also share in the chat the link to our YouTube page where you can find this webinar recording and probably by the end of the week, and all previously recorded webinars in the series. So keep your eyes peeled on the chat box. I'll be throwing some helpful links there, but I will hand it over to Caitlin, who will introduce our speakers joining us this webinar.
Great. Thank you so much, Jillian. I appreciate that. So, all right, let's go ahead and get started, folks. All right, so hopefully you are all here for the AICP exam prep, and we're going to talk about law and some of those items in the exam outline. I want to note that we're not going to comprehensively go through like every single case that you're required to study, or really every single bit of that exam outline. We're just wanting to cover really the essential, important legal concept and some of those really important cases and case law that you might interact with on a daily basis on your job. Just to introduce myself, hi, Caitlin Aubut, Professional Development Officer for APA Virginia. My day job, I work as a planner with York County, Virginia. Want to introduce our two speakers. We have Adam Kinsman with James City County, he's the county attorney, and then Maxwell Hlavin with Sands Anderson, local government attorney. And I'll let them both introduce themselves right now and give you a little more background.
You're younger. You want to go first?
Beauty, or you?
Oh, age before beauty. Good morning. I'm Adam Kinsman. I'm county attorney for James City County. In a prior life, I was a planner for York County as well. Caitlin took my job and I went to law school. And then let's see, I worked for Sands Anderson for a couple of years, and I've been with James City County for 20 this year, which means I'm getting ever closer to the light at the end of the VRS tunnel. So some of us might have left private practice and don't have that VRS tunnel. So
Yeah.
Max.
Yeah, my name is Max Hlavin. I'm with the firm of Sands Anderson. I do a lot of local government work and focus on land use and sort of economic development, transactional and general governance issues. I actually worked for James City County in the county attorney's office for about 8 years before transitioning to private practice a couple of years ago. So Adam and I sort of had the inverse career path there. But yeah, we're really happy to be here and helping out with the APA Virginia test prep.
Fantastic. Yeah, thank you guys both so much for dedicating your time to this. I appreciate it. So, gonna briefly, there we go, my slide will advance. Just a little brief outline of what we're going to cover this afternoon. We're going to talk about some of those constitutional foundations and core legal concept that underpin a lot of really what we do every day, that core of land use law. We'll talk about, again, just a few selected landmark legal cases. There is a lot out there. So, I do encourage you, if, while you're doing your studying for exam, go over all those cases. They're all important. But again, we're just going to focus on a select few. And then we do want to dedicate a good chunk of time to question and answer. This is your time to ask Adam or Max, again, any of those questions. Could be about things we talked about, could be some other things. Maybe as you work your way through the exam outline, you had some like floater questions. They're very qualified to give you those answers. So to start us off, we're going to talk about some constitutional principles. So First Amendment.
We could really sit here and talk for an hour and a half on First Amendment if we wanted to. It was kind of hard to figure out how we're going to cut this back a little bit. I'll go over some general principles of First Amendment. First Amendment, as we all know, it says Congress can't make any law abridging the freedom of speech. Like everything, though, there's got to be some boundaries. So it's not a free for all, and government is allowed to put some restrictions on freedom of speech. Public forums can have content neutral restrictions, and we're all pretty familiar with those in all of our planning commission meetings, board of supervisors, city council, townships, all of that. Those are your time, place, and manner restrictions. And if you want to think about it in terms of a commission meeting, we do that all the time. You're making restrictions on freedom of speech. You're saying what time is the meeting, what time is that particular hearing. We have restrictions on how long people can talk. And at times we have restrictions on about what they can speak. So most of us have planning commission meetings where you have, say, 4 or 5 different hearings. Some of you guys up in Northern Virginia probably have 20, 30 hearings. And you say, hey, you can talk about case number 2 when case number 2 is heard. You can't talk about case number 3 during case number 2. You are actually restricting that person's First Amendment right to speech. And we're allowed to do that because it's just time, place, and manner. One of the things I thought about too was, like, what if you had 100 speakers coming in? You got a long day, you've got 100 speakers coming in, and you learn that 99 of them are against it and 1 of them is for it. Can you put a restriction on the 99 to where they only speak for 1 minute and the person that's for it gets to speak for 5? And you can't do that. Everybody has to have the same. It needs to be neutral. So if you decided that 99 against only get 1 minute, you are impermissibly restricting their viewpoint. We had that. I imagine a lot of us had the ones where we did the Second Amendment sanctuary city thing, where we were saying that we're gun friendly. We had here at James City County a line of like 500 speakers that were going to come out and speak for it. We did do a restriction and we cut everybody down to 1 minute apiece, but it didn't matter whether you're for it or against it. You just got 1 minute. It sort of angered a lot of people, but trust me, after the 20-second one, they were all saying exactly the same thing. And they just kind of came up and said, yay or nay. So that was one of the things that the board was asking me really on the fly. They said, hey, we've got a line out the door. Can we restrict these people? And I said, as long as we're doing it as one, we're fine on that. So those are at least some of the time, place, manner things that we often hear. Max, and we
yeah, I mean, that roots exactly in the language of the First Amendment, which, which is then incorporated to the states or passed down to the states through the 14th. But, there aren't supposed to be laws that abridge the freedom of speech, or prohibit the free exercise or the establishment of religion. What Adam's talking about is abridging the freedom of speech. And as long as those regulations are content neutral, and that's the key thing, is you want to be thinking about, is what you're doing truly a neutral regulation based only on non-content of that speech, then you have the ability to put those reasonable time, place, manner restrictions on it. I also want to touch on the fact that the First Amendment isn't just free speech, right? Like, we always think about First Amendment, you can't, hey, you're interfering with my First Amendment rights. You hear that all the time, which first, in a private capacity, you can't interfere with somebody's First Amendment rights. So, but in our roles as representing government entities, and you all as largely government employees or officers, it is a consideration on whether or not speech is being abridged. It doesn't have to be completely prohibited to be abridged. So you want to be very considerate about treating everything equally, regardless of the content of that speech. But First Amendment also includes, the religious exercise. And there's two components of that. One is not establishing religion, and the other is not prohibiting the free exercise of religion. And those are two different but related clauses that planners and local governments still need to be cognizant of, because we can't have any particular planning policies or ordinances relating to zoning or any land use that would unnecessarily or explicitly prohibit the free exercise of religion, nor could there be preference for one religion over another. And you might see some of that, not intentionally, but held over in sort of older ordinances, where particular religious assemblies, whether it's just because they were described as one thing or another, would tend to have a greater impact on one particular religion or another. And so those are issues that you have to be thinking of from a First Amendment standpoint, as well, that aren't necessarily speech related, but could be related to the actual policies of the locality, for how the construction or placement of a church is treated versus a mosque or something like that.
Or days in which they're like, if we're looking at traffic impacts and whatnot, and most of the Christian denominations are Sundays. There are certain other ones that are not, and they're Saturdays, Wednesdays, and we've sort of dealt with that here. Another thing, not so much for planners, but attorneys, I cringe every time I'll go to other meetings, and you'll have some sort of a prayer or a thought process, some sort of speech that happens during the meeting. For the most part, that's fine if you're talking about an overarching God, but once you start bringing in, I like to pray in His name meaning Jesus, that is more of a sort of a thumbs up for Christianity versus something else. And so it's a very delicate balance when I'm telling people it's fine for you to put your head down and pray, but please don't say Jesus. And I've run into some issues with that before, particularly when you'd have police functions and whatnot. They always have the chaplain speak, and that's a very tight line.
Yeah.
So
yeah, I mean, Adam's exactly right. That's maybe one of the most uncomfortable situations to be in from an attorney standpoint. It is that opening invocation, and what does that look like, and what the general practice of a particular governing body or deliberative commission or whatever it might be. squaring that entirely with First Amendment is a very tricky task. And, obviously the best you can do is give good advice, but you also have to be considerate of the inverse of the situation that Adam's describing, which is if you are telling someone not to say a particular thing because it could create an issue for the body itself. If that person is giving an invocation from an external organization, you're also telling them what the content of their speech can and can't be. So you have to be very careful about it on both sides of it. And so the best thing to do is just not have invocations at your meetings, but like obviously that you got to deal with the world that you live in.
We just have a moment of silence. The way they got around that was the preacher would actually speak during public comment, and during public comment session, that's a much more open venue, and they can say whatever they want to, and I can't stop them from saying that, and don't try to stop them from saying that. Perhaps something a little bit easier for us to think about in meetings, and that will tie back to a slide that we'll get to much later in the process, are signs. A lot of people want to come in and they make buttons and signs and all that things at a meeting to say, I'm for this, I'm against it, Citizens Against Rezoning. And we can have regulations, and we do, that prohibit all signage of a certain size before coming into the board meetings. So you can't come in here with a big giant poster that then really sort of blocks other people's view of the hearing and blocks our cameras from transmitting it on the county channel that I really think only my wife and mom watch. But we're always thinking about who's watching. So we don't read the signs. It's simply a size measurement that we do. And we say, hey, it's too big, you got to take it out. And again, that's how we're doing it, in a content neutral sort of way, just measurements.
Yeah.
And that'll tie back in a little bit later. So I think we probably said all we're going to say about First Amendment, unless people have questions or you want to get into the nitty gritty of it. Nope. All right, Caitlin, roll on.
All right. So the next sort of big concept that applies broadly in land use planning is due process, which has two components, but basically the Fifth Amendment, which is then incorporated into the states by the 14th Amendment, which has a bunch of protections in it, but there are really two that are most applicable. One is sort of the substantive issues related to due process, which is the government taking reasonable action that's in furtherance of a public purpose as allowed by a particular statute or law in the case of the federal government or the Constitution. And then the other is procedural, which is, are you giving folks enough process that they can make sure that their rights are protected before you take any sort of adverse action, which comes into play sort of through whether it's a special use permit revocation or a zoning violation or something like that. But there's also a procedural aspect to the operations of government decision making generally, which really is procedural due process, and you see that in the public hearings and the notices that go along with ordinance amendments and things of that nature. Which, as long as you are complying with the requirements of the statute, then you are complying with constitutional due process from a procedural standpoint.
You probably didn't even know you're doing procedural due process. And that's something that the General Assembly, as we all know, they mess with that every year. That's one of the reasons we have to keep up with all of the General Assembly actions. And I would say 75% of what they adopt has to do with procedural due process. So, for example, you can't take that action unless the neighbors know about it. Well, originally, they probably just put it in the newspaper. Well, maybe the newspaper ran it, maybe they didn't. So the General Assembly added and said, well, now you have to mail it to people. mail it to people, and then someone probably went to the General Assembly and said, I didn't get that mailing. And then all of a sudden, now we're stuck with certified letters, which we all know and love, and it ruins all of our budgets. As we all know, we have to put certain language in the newspaper to make sure that people know what's going on so that they can have their moment in the sun at the board meeting with their sign or whatever. And the General Assembly changes that every year. How many words do we have to put to let people know that they're on notice that something's happening at their government? And that's part of our procedural due process. How many trips do we need to take through the planning commission? How we got to have a public hearing or don't have to have a public hearing? That's all part of the procedural due process.
Yeah. So you don't see substantive due process come into play very often on a like day-to-day basis in planning, largely because planning is it's got a pretty long tail, right? So like these decisions are generally made based on a lot of data, based on comprehensive planning that's years if not decades in the works. It's based on recommendations flowing through policy committees and planning commissions and up to a governing body, and there's a very full record of why something is being done. And so generally speaking, is there a reasonable connection to a legitimate government interest? Yes, right. Like you can almost always demonstrate on a sort of general basis that that substantive due process is satisfied. One of the caveats to that is part of substantive due process, sort of a subset of it, is equal protection, which is also part of the 14th Amendment. And that can create additional issues for someone. That's probably what you're most likely to get even if it's not a specific legal complaint, someone to say like, well, you violated my due process. You've not treated me the same as somebody else. And that is part of substantive due process. But it's also very unlikely that there isn't actually an equal protection.
It's so much easier to challenge procedural due process. Yeah. That's why you see so many cases about it. Oh, they didn't send it on the right time.
Yeah.
It came to me on the 7th day and it was supposed to be coming to me on the 6th day. As an attorney, that's so much easier to challenge than the actual substantive due process. The board your governing body gets so much more deference in their decisions. They're going to be looking to you and us as to what did we do wrong to get it before the board, and that's mostly that procedural.
Right. Yeah. And in Virginia, since this is for folks who are part of APA Virginia, the test for have you complied with substantive due process is basically whether or not the decision was fairly debatable at the governing body. And if there's really any evidence in the record of reasonableness, then you're going to have satisfied that fairly debatable test. And that's really the threshold, right, for substantive due process.
Which is way low.
Which is way, way low. And so as long as decisions are being made in a reasonable way based on, facts that are in the record, you're almost always going to be able to support that and make sure that you're satisfying the 5th and 14th Amendment substantive due process aspects. It's the procedural stuff that is a little bit trickier.
All right, let's talk 10th, Caitlin. All right, so the 10th Amendment, that was adopted in 1791, and that's really a clarification that the federal government, their powers are limited and enumerated. And so really what that means is government decisions are investigated as if they were an overreach of power and authority. Supreme Court sort of kicked that around a couple of times in a couple of big cases. In 1958, in Cooper v. Aaron, Arkansas, that was found that Arkansas couldn't delay desegregation because that violated the Constitution. And in 1995, in the Lopez case, it said there was a federal law that established gun-free zones in all public school campuses. And they said that's unconstitutional because there was no law that authorized it. So again, that it said there's some boundaries on what a federal government can do. So the really what we're looking at is the Constitution doesn't keep land use at a federal level. That actually falls down to the states. And that falls, I think, I'm flipping my thing here. If you flip that page, that really does fall into the police power. Go to the next, the next slide. So that really goes to your police power. It says that the federal powers are limited to things that affect the country as a whole. So that's, I've tried to think of some stuff: foreign policy, currency, war. The states and the localities help protect public health, safety, and welfare. And those are the police powers: health, safety, and welfare. And that includes land use restrictions.
Yeah, I think if you think of it like very big picture, the Constitution has articles, right? There's Article 1, the legislative, there's Article 2, executive, Article 3, the judicial branch. And within Article 1, essentially the amendments say the federal government can only do certain things within Article 1 power. They can only legislate, within what they're, been explicitly told they should be doing, what are their like core functions of the federal government. And everything else, the states get to decide. And so land use is, there's Supreme Court language exactly on point. It's like, it is the most local decision that could possibly exist, right? There is no place other than the amendments that we're talking about, the 1st, the 5th, the 14th. There is no place for the federal legislature to talk about what can happen in York County, right? Like, it just doesn't make any sense. And so that power explicitly now through the 10th Amendment is reserved for the states, even though I think it was sort of it could have been understood otherwise, but it's reserved for the states. And then, in Virginia and all kinds of all the other states, the legislature then gets to decide at the state level how that police power is sort of delegated or utilized. So that includes, things like eminent domain, which is authorized under the Constitution because the 5th Amendment says, and then given down to the states by the 14th, says that you aren't supposed to take property without just compensation. Well, that means you can take property, for a public purpose. You just have to pay just compensation for it. And that's where you get into, is this an eminent domain situation where the government is, as authorized under the Constitution, actually taking something for a public purpose, which, public purpose sort of has its own its own questions. And after for example, that Kilo case that came out, I can't remember, it was in 2010, I think,
or 2005.
Okay. Everyone's like, oh, economic development is now a public purpose. Like, the government's going to be going around and the federal courts have now said that the Constitution allows for government to use this power that they have inherently for their economic development goals. And whether or not that is still the law from a constitutional standpoint, but then states went ahead and restricted that as they deemed fit. Like, some places were like, great, okay, this is now part of our constitutional powers, we're going to go ahead and utilize this. Other places like Virginia passed statutes or amendments that said, whoa, that is not what's authorized. As the 14th Amendment has said, the state can use eminent domain, but we're saying in our Constitution, it's not allowed to be used for economic development purposes. So you can see that sort of separation of powers at the federal level to the state level, and then the states being able to say, well, yeah, although we're allowed to do this, we also are, authorized to restrict our powers as we deem appropriate. We don't have to use the full constitutional breadth of our powers if we don't want to. under our own state constitutions.
Yeah, it's so I will admit that well, I did really well in law school. I will admit that my worst class was constitutional law. And so let me sort of back it up and make it really simple because it was trying to like how I think of it in my head. You have the federal government that we set up and it said, okay, all powers are sitting at the federal government. You had the states that were joining in and said, well, we don't want everything to be at the federal government. So let's say the federal government has these certain powers. If we don't say what exact powers they have, then through the 10th Amendment, all of that flows down to the state. So you're going to have this sort of flow up and down of power. The federal government has it. If it's not listed, 10th Amendment said it goes to the states. The states then let it go to the localities. Localities are using that through their police power. So through our police power, we can use eminent domain because it says we can. Then at some point or another, someone took something that they probably shouldn't have, or let's say they took it and didn't pay for it, then you get, well, you have to have just compensation. Then they took something that someone believed they shouldn't have, and you put a little bit more limits on it. And so Kelo was a case where the Supreme Court said you have pretty broad limits on what you can take and say that it's a public purpose. And if you remember in Kelo, they literally took someone's private property and then immediately flipped it over to another private entity. So it didn't come into the government and wasn't used as a park. It was for economic development. Government said, well, economic development is a public purpose. And the Supreme Court agreed. And so then what happened is the states, again, looked at the power. Some of them, like Max said, took some of that power back, or at least gave us some boundaries on what we could or couldn't do it. I don't know if you guys end up having to do a whole lot of just compensation determinations, but just compensation, how much you pay somebody for their land, it's supposed to be a fair market value. That alone is different in every state. It's the subject of a ton of litigation. It's sort of hard to get that concept, but so everybody has a different idea of what just compensation is. The government would say it's what we assess your property for. A landowner will say it's what I get my property appraised, typically by an attorney, and that appraisal value is going to be a lot higher than what we say. So we fight over what just compensation is. One of the things I wanted to think about too is that when we sort of bounce between eminent domain and takings, there is eminent domain where I'm going to go in, that maybe is the easiest one to think about, and I'm going to take your property, like in Kelo. I'm going to own all of it and I'm going to sell it to somebody else or make it into a park. There's also regulatory takings, and
Yeah.
there's a fair amount of gray area in that.
Yeah, I think so. They're directly related concepts, because eminent domain is the authority under which a government entity can take property from somebody. And like Adam said, they have to pay just compensation under the Constitution. That in Virginia is basically fair market value, and the state legislature has created a very, very particular framework within the statutes on how government agencies can utilize the power of eminent domain. And that's really for physical takings of property for a use, whether it's utilities or a park or a school or whatever it would be. That's what you traditionally, are thinking about the use of eminent domain. But there's also, inverse condemnation, which is a private right where a property owner can say, well, you have taken my property physically, but you just didn't go through this correct process, and now you need to compensate me for it. You see that in, a lot of instances where there'll have been flooding related to a public facility, or like there's a sewer outfall that makes a property unusable for an extended period of time or something like that. And then there's an argument to be made that the government has taken that property or some aspect of it for a public purpose without having paid the just compensation for it. But like Adam was saying, that takings line of reasoning extends past just physical interference with property right, and it has now grown into regulatory takings, whether those be sort of categorical regulatory takings or are sort of pure regulatory takings arguments about, you have so interfered with my investment back expectations through this regulation that it should be, in my instance, considered a taking of my property.
And it makes sense. Like, if we all know that if you have to pay just compensation, it's expensive. You may not have the financial wherewithal in the county to do that. So if you think about, you're looking at a really nice piece of property that someone wants to come in and develop 100 homes on it, and the government decides, well, we don't want 100 homes on it. Rather than going out and taking it and buying it and making it into a park, why don't we just do regulations that limit them down to almost nothing? And we take away 99 homes and we decide that you can only do 1 home there. It's something that someone could say, well, you practically took it. You took away all 99 of my rights and I'm down to 1. I'm trying to think of some of the other ones that we've done, but you can think about it. We have the power to make regulations that affect development, both positive and negative, and we could adopt enough regulations to keep you from developing it altogether. And at some point, people have been fighting that back in court, and the courts have now recognized regulatory takings.
Yeah.
All right, go ahead and flip it, because then we'll talk a little bit about vested rights.
Yeah, I think we'll talk a little bit more. Like, takings are also related to this sort of exaction law. Like, exactions are a form of taking. So we'll talk about that a little bit more later also. I'm going to hit Dillon rule, home rule before we get into vested rights. So I'm going to move in I think is it Hebrew that you read right to left as opposed to left to right? I'm going to move in the Hebrew fashion and go right to left on this one. When we're thinking about police powers, there are 2 general philosophies in the states. One is the Dillon rule and one is home rule. And Dillon rule is what we have in Virginia, which says, local governments only have those powers that are explicitly given to them by the state legislature, or that are necessarily or fairly implied from those explicitly given powers. So it's a rule of construction where if you aren't enabled through the state statutory language, then you don't have authority to do it. It's ultra vires. So it's as if you didn't do it in the first instance. And that is the inverse of what is the case in home rule states, which say, no, local government, all the power roots from the people, capital P, and local governments have the authority to do whatever they want to do unless a state legislature tells them they cannot do that, because that's a higher legislative body and they have the ability to say, no, don't do that anymore. We're taking that power away. And really, it's bandied about as this like major difference. But when it comes down to it, you either have the power and someone takes it away, or you're given the power and they take it away piece by piece at the state level. So from a practical standpoint, it doesn't really have that much impact on like day-to-day planning, other than you can do something quickly in a home rule state and then the state will say, don't do that anymore, and no one can ever do that again, versus that being a slower process in a Dillon rule state where you really have to maybe advocate for some authority at the state level. But in the instance of zoning or land use, the powers delegated from the General Assembly to the localities are very, very expansive. So it isn't a case that each little thing has to be authorized, because the state has said zoning is a public purpose. It is part of the police powers, and we are hereby telling the localities that you have the authority to do this, consistent with the very broad language that is included in chapter 22 of title 15.2. And so it's sort of like a home rule environment in a Dillon rule state when you're talking about the zoning authority, because the delegation is so broad. and then you see like where the General Assembly comes back and takes that stuff away piece by piece, just like they would in a home rule state, where they said, okay, you have general authority, but you can't have special use permits for this, and you have to allow that, and you're only allowed to think about these 6 things, and when you're talking about, this other thing. So
yeah, it's fun to say that we hate Dillon rule state, and I'll say that all the time when I do the presentations. I wish we were home rule, but I've talked to friends that are at home rule, and they said, well, your code section just is a bunch of stuff that you can do. Mine is a bunch of stuff I can't do.
Yeah,
it's really not any big difference. And just one final thing on Dillon rule, we're in the minority. There are very few states that are Dillon rule states. You're going to find most of them are home rule. Moving over to the left-hand side of the page, vested rights. Vested rights, if you think about what I was speaking about before, where we have all of this power, and then sometimes we'll impose certain things on people or try to stop development by adopting a new regulation. The theory of vested rights is basically, when has someone done enough that you tell them you can't tell them to stop. Really, that's all it is. It existed in common law for a very, very long time, and it wasn't until fairly recently that it got codified, where the code says, basically, here's what it means to be vested in what you've done. Vested rights come about before a non-conforming use. So this is something that's being planned, not something that exists. And I did want to say they're distinctly different than grandfathering. A lot of people will say, I'm vested or grandfathered. And I'm like, well, those are 2 very separate things. Grandfathering is when your legislator puts a carve out in the legislation itself. So they effectively say, here's if you weren't vested, here's what it means that we'll just ignore you on these things. And most of the time, at least here, we'll do that to appease people who would have been against the legislation anyway. For example, we just adopted a giant downzoning of James City County, where all of our agricultural property was 1 house per 3 acres, and we switched it to 1 house per 20. We knew that there was going to be a fair number of people in the upper end of the county that would have been really upset about it and probably would have turned the tide, when really we were just trying to address these really big parcels that could be really big neighborhoods. So they adopted a grandfather clause in that legislation and said, anybody that has a 25-acre parcel or smaller, you're still going to be able to do 1 for 3. As long as you have that 25-acre parcel on the date that we adopted this, you can still cut it down to 1 for 3. So they weren't necessarily vested. They hadn't done any of the things that the code says means to be vested, but there was a legislative carve out, and they became quote unquote grandfathered, not vested. To be vested, the code is really specific, and it says you have to get a significant affirmative government act that remains in effect. You have to rely in good faith on it, and you have to incur extensive obligations or expenses in reliance on the affirmative act. So basically, the government has to say, yes, you can do this. You have to start doing it, and then you actually have to expend some resources in that effort.
Yeah, there's 15.2-2307 is the statutory treatment for vested rights in Virginia, and that's it.
But hey, and just by the way, Max is smart, but he has it open on the computer over there, so I didn't want anybody to think that he's just pulling the stuff out of his head.
Not true.
He's not that good.
Not true. I just have to deal with it a lot, so I know it. But I do have a statute up that we are going to talk about in a little bit, because I couldn't remember that one. But so that sets out the statutory framework for how rights vest, and that's specific to zoning. So like Adam was saying, there's and that also contains the authorization for nonconformity in that same statute. So vested rights, you haven't done it yet, but you
got close enough.
You got close enough. You've been relying on what the government said you could do explicitly, and you've gotten close enough, so you get to continue doing it no matter that the ordinance changed and now you can't do that anymore. And like Adam said, the nonconformity is something that you've already started doing and the ordinance changes and now you can't do it anymore. There's also the ability to address as sort of a fundamental fairness. It's not vesting through grandfathering like Adam was talking about. those certain plans that have been turned in, but maybe haven't vested. If there's a large policy change happening at an ordinance level, a governing body might say, all right, we understand we're making this, very, very broad ordinance change. And there might have been people that have applied but don't have approvals or something that would operate as a significant affirmative governmental act before the change. And that wouldn't be vested, under the traditional framework of how to evaluate a vesting. But they might say in the ordinance, well, we're going to allow all of those applications that have already been filed to be treated under the ordinance as it existed as of the date of their application or something like that. And carve those out from nonconformity and say, we're going to treat those approvals as if they are, everything that was pre-existing as lawfully conforming versus treating all of that stuff as now non-conforming. So there's a broad ability for governing bodies to grandfather or treat things that are existing differently than the amendment would have them be treated.
And you'll often do that just to appease people who are voters and who are going to be out there and
every
upset
time.
and
That's
and
the
mad.
only reason. Yeah,
that's where you're going to find grandfathering.
The other part of vesting isn't specific to zoning, but can happen with approvals of site plans or subdivision plats through I think it's 15.2, 2250, 9, 2260, 2261, where if something is approved as a preliminary plan or a final plan, they're allowed to continue on with that development, notwithstanding a change to the ordinance. And that's a separate but connected piece of
it is. It's a little bit less because it doesn't require that they expend a whole lot of money or whatever. They've gotten that affirmative government action. You approve that subdivision plat, then they say that's enough. You're good for 5 years.
Right. So like there's a limited sort of vesting specific to those specific plan approvals that you have to think about. And that is also from time to time extended by the General Assembly in Virginia.
For housing or COVID or
whatever.
Judicial emergencies.
Yeah.
Trying to think of all the ones that we've had over here. So
yeah, so that's a concept specific to Virginia as far as vested rights go, that planning folks and zoning folks run into all the time, because those are really complicated sort of time-bound analyses to be like, when did the thing come in? When did we approve it? Was it preliminary? Did they get an extension through the COVID thing? Did that cut off now versus, the housing emergency? Like it's a very complicated and, fact-specific analysis.
We try really hard at the through local government attorneys and everybody else to make them so you can't daisy chain those things together, because you're just resurrecting plans that are 10 years old and it's ridiculous. So
right.
Go ahead and flip to the next slide so we can start playing around here, Caitlin.
Awesome. All right. So we're going to get a little bit into some case law here. Now, I'm going to wake you all up, spark everybody up.
Wait, what do you mean wake them up?
That's what that's garbage.
It is lunchtime, so little food coma possibly, but
on everybody's camera. I bet half of them are munching. Come on.
So what we prepared for you, y'all, are two sample cases, and we're going to read through it and then have a little interactive poll element at the end to say, okay, what concept do you think applies? And then Adam and Max will kind of talk about that. So this one is takings focused. And Jillian, I wanted to check in with you. Are we all set up for great? Okay. I think Jillian will explain how you vote once we get to that question. So in our sample case, we have a big development corporation versus City of X, and they own a parcel of land along the Green River. Property zoned for commercial use, and big development has approved for site plan approval to construct a 3-story shopping center with restaurants and retail stores. And the property is in an area that has been identified by the city as having lots of traffic congestion issues during peak hours. The city's planning staff reviewed the developer's site plan and their attached traffic study, and they determined that the proposed development would increase traffic by 15% in that area. As a condition for granting site plan approval and building permits, the city required the developer to dedicate a 50-foot wide strip of land along the riverfront, which would end up being 20% of the total property, for a public trail. They would have to construct and maintain that trail at the developer's expense, and they would have to make that trail public access. The city justified those conditions by saying that the public walking trail would provide alternative transportation options for residents and then would reduce traffic congestion. The developer argued, they were willing to implement traffic mitigation measures directly related to their development's impact, such as, putting in a turn lane or a traffic signal, but requiring them to dedicate land for a public trail constituted unconstitutional taking without just compensation. So after exhausting all their administrative remedies, the developer filed suit challenging the permit conditions. So our question for you all: did the city's conditions constitute an unconstitutional taking? Our first answer is yes, because the conditions are opportunistic and unreasonable. Yes, but because there's not an essential nexus between the conditions and the legitimate government interest, it's a reasonable condition, or I don't have any clue. So Jillian, how does everybody interact with that?
Alrighty, let me go ahead and launch. So
Look at this.
Ooh, fancy. Okay.
you should be able to see your multiple choice options on the screen, and I'll just wait until we have close enough to full participation in the poll before sharing the results.
Max tried to click the first one, but we can't.
I would have clicked the fourth one.
That's bogus,
Yeah,
Jillian. How come we can't vote?
I would have clicked the fourth one. I don't.
Alrighty, we're almost at about 70% completion, so I'm going to go ahead and close voting.
Hurry up and vote, Dave Watson.
All right. So looks like we all generally agreed that, yes, there's not an essential nexus between the conditions and the legitimate government interest. I wonder which case we're talking about. All right. So Nolan versus California Coastal Commission. I'll let Max and Adam talk about this one a bit. This is a super important case, and hopefully you all remember it possibly from when you were in school, but if not, we're going to run it down and how it impacts us.
So that one, they were, gosh, it's funny. I have a picture of it. I don't know how. That's what it looks like right there. They had a new house. They were going to build a new house. It was 2,500 square feet, and it was originally 504 square feet, and it was going to increase blockage of the ocean view, and it was going to be like you can kind of see sort of a wall of structures where someone going by on the other side wasn't going to be able to see the ocean. And
that's Adam's high-tech contribution to this presentation, is holding up the 8x11 picture.
Where's your pictures, mister? All you're doing is playing with your computer over there. Anyway, so what they said is, what we want you to do, we'll let you build your 2,500 square foot house, but you've got to dedicate a public easement laterally across the beachfront of the property. And if you do that, then we'll let you build your house. And the Nolans fought that and said, no, this is unreasonable. What does that have to do with anything? Effectively, how does that help? How does the dedication of an easement along the beachfront alleviate the problem that you've identified, which is view of the ocean from the street on the other side? And it didn't, and that fell at the Supreme Court. They sort of kicked that around and said, the Supreme Court said, well, you could have done a height limitation, or you could have done a width restriction, or you could have done a ban on fences. You could have required a viewing spot, but you didn't do any of that. What you did is you made them dedicate an easement in front of the beach. and that's not working.
Right. I'm gonna give some kudos to
Me for the picture?
well, yes, to you for the
Thank
picture,
you.
but to Caitlin, because I think the fact pattern that you described is more complicated than Nolan v. Coastal Carolina. I think it is a trickier analysis than the court was presented with in that case, because like Adam said, there wasn't really a connection between the impact and the public purpose that the condition or the withholding of the approval was designed to address. Whereas in your fact pattern, there is a 15% traffic impact. This is retail, right? There are things that would demonstrate that perhaps some alternate routes to access this use would be appropriate, and there would be a nexus to the use, but there isn't something specific to foot traffic, or that isn't part of the facts that that are provided. So I don't I think it's still, it falls within this Nolan framework, but I think it is a trickier case than Nolan itself was. So I think that was well crafted for people to sort of think through those very critically.
Yeah, I think, Max, to your point there, in my little fake case write-up of like, why would this be, an example of like a lack of reasonable nexus. It kind of felt to, hypothetically, the city in this case was not able to present to the court, that some sort of proof that this is how this trail would alleviate the traffic. And I think if they had that, or if that was part of a traffic analysis, that would change the outcome of this situation. So yeah, I agree that I think in real life, it's not nearly as clean as, like the actual case of Nolan.
Yeah. Yeah, I do think it's a good example of thinking, critical, and we're going to talk about Dolan also, but thinking critically about that nexus. And traffic, it doesn't mean any kind of traffic, right? Like, you've got to be thinking very critically about what are the impacts associated with the particular application or the proposed development, and tying those, as an essential nexus, not just like reasonably connected to them.
All right, hit the next one, Caitlin.
Thank you. All right. All right. So here's another practice case for takings. Well, you guys can probably figure out where we're going from here, but so this is a hardware store, hardware versus a town. So the hardware store, they own a parcel in the town of XYZ, and the property is located near a creek, which floods during heavy rainfall. The hardware store applied for a permit. They want to build a 30,000 square foot hardware store and a parking lot on the property. And that would increase the impervious surface of the previously undeveloped parcel by about 65%. So the town's planning staff reviewed the application, the site plan, and they noticed, okay, there's a lot more impervious area that's going to increase stormwater runoff. It might contribute to downstream flooding issues in this creek that's right there. And then they identified, again, a traffic issue on adjacent streets, particularly on Main Street during congestion peak hours. So the town required the hardware store to dedicate a portion of the property within the 100-year floodplain, which would be about 40% of the property, as a public greenway for stormwater management and recreational use. And they also required them to dedicate a 15-foot strip of land along the street for future road widening to accommodate traffic. And the developer acknowledged that, yes, stormwater management is something that they need to deal with, and is traffic mitigation, but they argued the requirements were excessive compared to the actual impacts of the development. The developer proposed alternative solutions, such as larger on-site retention pond and turning lane improvements, which would, they felt, address those concerns while keeping their property lines. The town disagreed, and so they proceeded to a, hypothetical case here. So again, those are those conditions. And for our second poll case, our question to you is, are these an unconstitutional taking? And then yes, because they're opportunistic and reasonable, not roughly proportional, they are reasonable conditions, or you're not sure. And if y'all haven't picked up on it, there's a theme here. So
Alrighty, it looks like we have the most that we're going to get in.
cool. Thank you, Julie. Yay. All right. So looks like the majority agreed that these are not roughly proportional conditions to the impact of the development. So this is kind of a test case for our, you'll hear again, Nolan and Dolan, and they're referred to together for a reason. Dolan's also very important and it builds on Nolan. And so Adam and Max, if you want to get into that a little bit for us.
Sure. So Dolan, for those that don't remember, these folks were doubling the size of their store. It was going to increase impervious surface, increase traffic. I mean, the store's getting bigger. And so what they said is you've got to give to the locality a area for pedestrian bicycle pathway improvement. So you need to give us an easement, and then we're going to go ahead and put a bike and pedestrian walkway through there. That was overturned. The court said that lacks a rough proportionality. The city failed to establish why the pathway easement was required to address the increase in traffic. And they only gave generalized statements that it could offset traffic demand. And I think one of the things the court really looked at and harped on was, why do you need to give an easement to the locality? Again, you're taking real property. You haven't done this particularized analysis as to why you need it and why that's going to offset the impact that you've identified. And I'll say, we talk about Nolan Dolan all the time. Nexus, rough proportionality, and you're thinking, well, it's probably never going to pop up in my practice as a planner. I'll tell you it. I thought the same thing, even as the locality's attorney. I'm like, these never really come up. I had both of them hit me square in the face about a month ago. So along Route 60, there's a developed piece of property. It was a lumber yard, and they kind of have a number of different things going on over there. And then in the back of the lumber yard, they have a permitted area for recreational vehicle storage. And that's been operating for a while now. So the people came in and they wanted to put covers over the RV storage area. We're not talking many. I think it was in the teens. And basically they're just carports. And I guess they can charge more because the rain doesn't fall on the rubber roofs that then weather themselves. So in James City County, once you do that, that triggers the site plan process. The site plan process requires us to look at traffic and bikeways and says that if you're doing a site plan for a property, then you need to install a bikeway and a walking path over there. So there's absolutely no impact that would require a walking path or a bikeway by covering existing RV storage. And then two, we say you actually have to donate that to the county. We'll take care of it because VDOT doesn't want bikeways. So for these people doing, speaking with their attorney, about $20,000 or $30,000 worth of covers, we're going to require them to do $250,000 worth of completely, wholly unrelated traffic improvements up front of the property. The attorney mentioned it and said, he said, gosh, that doesn't sound fair. Never mentioned Nolan Dolan. I guess those two names escaped him at the time. So what we did is we had them go ahead and bond it. I have an agreement with him. They bonded the work, and we are now working our way through ordinance amendments to recognize that not all property is new, and we're in a different time in James City County where we're having some redevelopment. And we need to recognize that certain redevelopment of property doesn't give need to some of the things that we would have with a new piece of property. So surely, if they're starting a new lumber yard out there, we're gonna have traffic. That's all brand new traffic, but and the ordinance that's a one size fits all, that works great, but it did not in this case. And I never thought it, but it was like, wow, that's Nolan Dolan almost to a T. You have to give us a walkway, and it has nothing to do with what you're doing.
Yeah, a lot of times ordinances will include like a carve out for, not carve out for this specific instance, but they'll say, if there's a requirement of general applicability that, you definitely want to have in there, because when someone comes in with a major site plan that's going to generate, foot traffic, you want to have that in there, to rely on, but allows a zoning administrator or a planning commission to modify the requirements for a particular, site plan application. So there can be some like safety valves built into an ordinance. But yeah, I mean, they come up all the time. And again, I want to note that the example, I think, is again is a tricky example that Caitlin crafted, because there is some connection to these issues. The question is whether dedication of that for recreational use, like dedication of a greenway, is really connected to the impact and is proportionate to that impact of the proposed development. And whether an expansion of the road would be required, or as the applicant proposed, is a turn lane really sufficient for the impacts specific to this particular development. So it's not an easy analysis, I don't think, the way that it's drafted. I think it's a good example of how you had to be thinking about these things.
You can flip that one.
We still have this poll. We'll see.
Oh yeah, I'm gonna close this poll.
Okay. All right. So yeah, I don't think we need to talk about this case too much. Really, just it stands for the proposition that when a court is considering a regulatory taking on a sort of as applied basis, it's going to be looking at this Penn Central analysis versus a previous sort of substantive due process analysis. But you guys won't need to be thinking about that in your day-to-day, I hope. I don't think about it in my day-to-day.
Adam and Max, we got a question in the chat from, I think this is Katie. So she asked, how do takings issues correlate if features are part of a community's comprehensive plan, such as sidewalks, waterway paths for the public when reviewing site plans? So
that's a great question. That sort of is connected to what Adam was talking about, which is that those requirements they make sense from a policy standpoint. And when you're coming in with a new plan of development, there's probably going to be a reasonable connection to how the ordinance is anticipating the impacts of that development and particular public improvements that would be associated with it. Like if you've got a residential neighborhood and you want to have sidewalks, so there's some separation from the public right of way, makes sense. It's when you start getting further and further afield, and the impact and the details of that proposed plan of development are smaller and smaller, perhaps like a expansion of an existing business by 10,000 square feet.
Mm-hmm.
You've got to think about what you can require versus then having to fall back into this like potential exposure for an exaction, which would be a form of taking.
Yeah, I think it is. It's the further afield you're going from what the proposal is, that's when it gets really tough. So internal to the neighborhood, super easy. The comp plan says all new neighborhoods shall be walkable and have sidewalks. Well, you're creating the neighborhood, you're creating all of the impacts, then that I'm fine with that. I don't think we have any problem with that. It's then if you take it to my RV storage, the comp plan calls for, that's a community character corridor. The comp plan calls for all of that out there, but at its core, the public improvements are something the public should fund. And when you want to push that off onto the private developer, I want you to put something out in front of the place so that the public can enjoy it. I'm going to have to tie that to some impact with whatever it is that they're changing. And that's why it's sort of a new thing for us, because James City County has, for the most part, I mean, we have a lot of stuff that's not built out, but we were, for my past 20 years here, it was all brand new property that was getting developed. And so it's easy to have a one size fits all because everything's new. Now we're having to do those very particular analysis to figure out, even though the comp plan calls for it, can I make them pay for it versus us paying for it?
Yeah. And this is actually a perfect segue into the statute that I had pulled up that I couldn't remember that Adam was teasing me for earlier, which is 15.2-2208.1, which is a provision that the General Assembly included to act as a penalty for unconstitutional conditions, essentially. And it does require for an applicant to object to a condition before any action, whether it's an approval or a denial, can serve as the basis of making a claim under this. But it is a state level acknowledgement that the General Assembly doesn't want to see exactions, that would be considered unconstitutional. So that's essentially, that's really where you get to from a Nolan and Dolan standpoint, is they're rooted in the Constitution. And I think this is a state level acknowledgement of we want to be very careful when we're thinking about those things, because the consequences, especially if an applicant is objecting to it, and it's not been a completely harmonious, application process, are pretty significant for the local government.
All right, Caitlin, if you want to flip forward while Max continues his TikToking over there. Pretending that's a Virginia code. I see how you work.
Yeah.
You can start with
yeah. So
yeah,
these two cases essentially stand for an acknowledgement that the Nolan Dolan test is still on the minds of the courts and the highest courts. And it is expanded, although Adam made a good point that it's not an expansion if it already exists as a constitutional concept, but it has been acknowledged as applying to money conditions and to even fee structures, which is, this latest Sheets case it could be a, forward thinking, how do we address this 1 hour webinar on its own. But we wanted to acknowledge these as, that the court is continuing to think about this takings, exaction, constitutional principles, Nolan Dolan, type of framework through the whole land use approval process, whether it's the fees to apply for, whether it's the consideration of the development plan itself, whether it's, legislative conditions, whether it's administrative conditions, whether it's cash that someone's saying they're going to pay for something else. It's really, soup to nuts going to be on the court's mind.
Yeah, whatever we're trying to get out of somebody, the court is going to look at it and see whether you had a particularized analysis of what it is that you're taking. The Sheets case was a guy putting a manufactured home on a piece of property, and they wanted, it was like $24,000 for contributions for traffic impacts, and the court looked at it and said, well, what does his one single family house have to do with your traffic impacts? Again, sort of going back to, you have these public improvements, it's on the public to pay for them. When you want to shift that fee over to the private citizen, then you better come armed with a lot of data as to why that use creates that problem that you're trying to fix by taking money from that person, money or property from that person.
mm-hmm.
Flip on over to signs. That's the fun one.
Yeah. All right. So hypothetical situation for you all, just to get you thinking about sign law, the First Amendment. So let's say you have your locality, you have regulations in your zoning ordinance for real estate signs, and they're different and they're stricter than your regulations for temporary yard signs. So are these regulations valid, or is there potentially a First Amendment issue? I think that, thinking about that, you'll probably want to think about, if my thing, Reed versus Gilbert, which a lot of you are probably familiar with this since it came out almost 10 years ago now, but this was a big case that caused a lot of us to have to redo our sign codes. and rework what was in there because of what came out of this decision. So
How is that thing 10 years old? Wow. It feels like
almost, you got 1 year and then we're decades.
yeah. So I mean, hey, whose sign ordinance, if you've been at this for a little while, whose sign ordinance didn't have those restrictions in them? I mean, everybody had them. From real estate signs to going out of business signs to off-site commercial signs. Heck, even we were regulating whether or not you have a shopping center and you have a group sign over there. Could you put the names of the businesses, or you can only put the name of the shopping center? We regulated the logos, everything. And this case really turned all of us on end. I mean, we rewrote our whole sign ordinance based on this thing.
Yeah, I think there are still, this sort of goes immediately back to the first thing we're talking about, right? Like, this is the First Amendment where the court has said, wait a minute, I don't care that everybody's sign ordinances are specific to the content. That's a protected speech issue. And in order to regulate that, you need to pass strict scrutiny. It's got to be narrowly tailored to meet a compelling government interest. And to have a justification in the record to meet that strict scrutiny standard is darn near impossible.
Mm-hmm.
So that just signals to everybody in the government world, okay, don't do this anymore, because there's almost no way you're ever going to pass constitutional muster if you have these content-based regulations. That being said, I think the court left open two opportunities that I see to make a distinction. One being commercial speech versus non-commercial speech, because they are treated differently. And the second being instances where you would be able to make a particularized finding, such as off-site directional signage. I think if you were to say we have to treat off-site signage a particular way, or we don't want it, or whatever it might be, directional signage, that I think there are compelling safety concerns related to those.
But you need to have a really good record of it.
Yeah, but you need to have a very good record of it. But I do think the court left open those two possibilities. But again, you don't see, political signs. Everyone used to say you can only have
30 days
political signs for 30 days. Like, forget it. You can't do that stuff anymore.
Well, we've just become a whole lot more diligent about pulling everything. I mean, we all deal with signs in the right of way. We pull them all now. It's political, non-political, whatever. If it's in the right of way, it goes. And I tell our guys, if you have to read it to figure out whether or not it complies with the law, it's probably a violation of Gilbert. So you just look at it, and again, we're just size-based now. Size-based and illumination or not. So
yeah, I mean, it's the same concepts that Adam talked about with the regulations on meeting attendance and speech, right? It's reasonable time, place, and manner things that are content neutral. And so it's not that it's impossible to regulate signs anymore. You just don't want to be thinking about the content of them when you are enforcing or drafting those regulations.
And keep in mind, content can be logos. The Target logo, we had one that said you can't have that, company logos, and they doesn't have any words on it. It's just a little Target thing, but that's still content restriction. So we removed all of that.
Yeah, it's
not just words.
You have to be very creative, but there are still ways to, address the public policies that were at the heart of those regulations. That you just got to find another way to skin the cat. I love cats. Don't skin cats. We'll talk. We can go to the next slide. We'll just, I think, breeze over this pretty quickly so we can get to questions. This case is, I just want to note, specific to the New Jersey Constitution. It is not a federal constitutional standard, and in Virginia, the courts have consistently held that the Virginia Constitution doesn't provide rights outside of what the federal Constitution provides. So we have sort of an equivalency standard here in Virginia. So affordable housing is a important goal. It's not going to be the same analysis everywhere as was sort of spoken about in these cases. And Virginia has a specific statutory framework for adopting affordable housing ordinances to incorporate into zoning. So it's sort of a different world in Virginia, I think, than these cases would describe, but they're still, I think, useful for general equal protection concepts and substantive due process.
And while you're amassing all of the many questions I'm sure we'll get, I just did want to mention that First Amendment really is in the minds of the justices, and we had the Freed case that came out almost a year ago this month, where they're trying to wrestle with, so you have a lot of old people in the Supreme Court trying to wrestle with First Amendment and social media. And that's something that we've been trying to be very careful with our board members, and that is also a relatively new public forum. And at what point can you regulate people's speech? Because we know everybody's super polite and kind on the internet. When can public officials regulate that speech as well? And that gave us a little bit of guidelines, but gosh, the guidelines are almost more difficult to figure out than not. And I've just told our guys, please don't ban somebody from Facebook unless you talk to me first. But First Amendment is kind of a really big deal right now with this particular Supreme Court.
Here's a guideline: take down the comments. Don't allow comments on your government websites.
Oddly enough, that was my solution to us as well. I was like, well, if you don't like them, just take them off. One, they like the good ones and they don't want to lose the good ones. But two, there's something with Facebook that said with government pages you can't turn off the comments, something to that effect. So anyway, that was an easy solution that I couldn't use. Caitlin, throw them at us.
All right, so we have a question. This kind of tracks back to like takings, nexus, proportionality. Question is, how are nexus proportionality tests handled in impact fee states? Is there a study that sets a per unit impact on transportation schools that holds up legally? Virginia is a proffer/conditional zoning state. Because of that, I've always been intrigued with impact fees instead. What are your thoughts?
That's a great question. I would say an impact fee framework would should be tied to the certain criteria and development thresholds that would pass muster on being reasonably connected. There being a nexus and a proportionality. That, to me, is the idea behind the impact fee framework itself, is to say, well, we're going to come up with an equation that basically equals nexus and proportionality and assigns a monetary value to that, and we just all move on with our lives, and we don't have to worry about sort of this negotiation, bespoke conditions or items related to plans of development that could come up which we do have in Virginia. And I'll say the proffers are a little bit different because of their voluntary nature. That being said,
Did you just say voluntary?
No, I don't say voluntary. I say voluntary because that's what they are. And there is this unreasonable condition framework set out in 15.2, 2303.4 that everyone has to contend with now, unless someone's going to opt to go with old proffer framework. But that basically puts you back into this same, even more narrow, I would say, analysis than, although it's designed to be essentially nexus and proportionality, it is extraordinarily limiting. So to answer the direct question, I think impact fees, there is a way to do that consistent with, takings. And I do think that conditional zoning is a special little thing for Virginia that sort of avoids it due to the voluntary nature of the exaction, because it has to be, required of somebody.
Although the Sheets case still stands for the proposition that we need to be very, very careful if we're doing impact fees that are applied to everybody, to make sure that you've done your homework ahead of time and that the application will withstand an analysis of whether or not it's fair for that particular person.
Yeah. Yeah.
So we have another one. With regards to Kuntz, is there any hope for the concept of growth paying for growth to become a reality? If not, it just means that existing taxpayers are subsidizing future taxpayers through existing and past infrastructure investment. Are there any constitutional issues or problems with existing taxpayers subsidizing future ones? Was the question.
I'm going to take the last part of it first. The first part of the question is a good question. And everyone wants to get to growth paying for growth. And that is consistent with the Constitution, I would say.
And we've tried to address that through proffers, but we all know no matter what you charge, it's always been sort of an interesting concept to me that you have someone come in and back in the days when you had set proffers and you said, okay, each house is we calculated it's going to cost us $50,000 because $40,000 for education of kids, because each house will probably have 2.5 kids or whatever it was in there. To me, it was always interesting because that addresses the first owners of it, but a house is going to be there for hundreds of years and it's going to continue to generate school kids through there. So it never pays for itself, even with the proffer system.
Yeah. And on the second part of that, I don't think there is a basis for a constitutional issue with the public at large paying for ultimately public facilities related to that locality, regardless of like who has driven the need for them. Yeah, I just don't, I think that is all sort of wrapped into our state tax system and local tax system that we have here. Now, maybe a little bit different if you're in a state that has, school board taxing authority or something like that, and there's a way to demonstrate that this particular development has necessitated this delta in the tax thing, but again, I just don't see a way there for our from the constitutional standpoint.
And it's not in existence in current Virginia code. There's just no way to do it.
Yeah.
Great. Anyone else, if you have questions, you can raise your hand, ask live, or you can drop it in the Q&A. That is all I had. Let's see if there's any. Oh, I got something in the chat. Hold on. Oh, thank you. Thank you too.
You're like that planning commissioner that I had that one time where, it's a late evening and you had people in the crowd and they're like, anybody else want to speak? Anybody else?
Yeah.
Is there anybody here that wants to talk? I know everybody wants to go home, but is there anybody else?
Great. All right. Well, I want to say, Adam and Max, thank you so much for doing this. This was fantastic. I think we all learned a lot, and hopefully you all watching, you taking the exams this spring or maybe even next fall, this helped, kind of, again, those questions you're going to get, a lot of them are application based and scenario based, and it's kind of related back to, it's good to memorize the case, but it's also good to understand how does it actually, in constitutional law, all that stuff, how does that apply in a situation? So thank you guys so much. Thank you, Adam and Max. Appreciate it. And I hope you all have a wonderful rest of your Monday, and good luck to everyone taking the test this year.
Good luck, everyone.
Yeah. Thanks.
Thank you, Caitlin, Adam, and Max. Everybody keep your eyes peeled on your inboxes for a follow-up email in the next few days with the recording, email contacts, and the slide deck. Thank you for being here.